أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله على سيدنا محمد وآله الطيبين الطاهرين اللهم صل على محمد وآل محمد. In the previous lesson, we examined the definition of the science of fiqh, or jurisprudence, or what we call Islamic law in general. In this lesson, we are examining the definition of legal theory, of usul, or the principles of jurisprudence. We've given many examples so far to differentiate between the two sciences. However, since this distinction is very critical for us to understand in this course, which is legal theory, the author of the book explains to us in detail what the science of usul is all about, for this to be understood by everyone. So in lesson 2, which is page 41, we examine what the science of usul is. Legal theory, what does it deal with? In the past, we've talked about this. We've said the common elements, the tools that it gives you to deal with all those narrations that we have in Islamic law. Right now, he will give us several examples so we can differentiate between fiqh and usul. So on page 41 in lesson 2, the author says, the science of usul can then be defined as the science of the common elements. Al-anasir al-mushtaraka, as we call them in Arabic. So the science of the common elements that you need in Islamic law, those common elements we call the science of usul. Used in the procedure of derivation of a Sharia ruling. So whenever you want to derive an Islamic law, a fatwa, a Sharia ruling, those common elements, the common tools that you will use to arrive at that ruling is what we call ilm al-usul. Now, in order to do justice to this definition, we must understand what these common elements are. We've talked about them numerous times, but here he gives us some more concrete examples. We will therefore provide some elementary examples of the procedure of derivation and compare their common elements. Let us suppose a jurist is faced with the following 3 questions. Number 1, is it forbidden for an individual who is fasting to immerse his head in water? If you're fasting, can you submerge your body and head under the water or no? That's one question.
Like swimming?
Like, for example, swimming where your head is underwater. If you're swimming up to your neck, that's fine. But the question is, does the submersion of your head underwater, does that invalidate the fast or not? That's one question. Number 2, is it obligatory for an individual who has inherited property from his father to pay khums on it? I inherited a piece of land from my father. Do I need to pay khums on it? The 20% mandatory charity in Islam. Do I have to pay it or no? Number 3, does guffawing, laughing out loud during a prayer invalidate it? If someone does a funny move and you're praying, right? You get distracted and you just break into this laughter. Does this invalidate your salah or no? So let's say you as a jurist, as a scholar, you're dealing with these 3 questions. Here, in the following examples, we will take a look at these questions based on the science of fiqh. In fiqh, how do you treat these questions? Then we'll get to usul and see the difference. The jurist will answer the first question, which was about what? About fasting and submerging your water. In the affirmative, meaning, yes, it's forbidden. Is it forbidden? Yes, it's forbidden to submerge your water. Based on what? If I ask a scholar who's dealing with the science of fiqh, Islamic law, I tell him, why is it prohibited for a person who's fasting to submerge his head in water? What will he say? Basing his ruling on a tradition from Imam al-Sadiq alayhi salam, narrated by Ya'qub ibn Shu'ayb. Ya'qub ibn Shu'ayb says, I heard the Imam alayhi salam say what? To the effect that immersion of the head in water while fasting is forbidden. So whenever you ask a scholar in fiqh, in the science of fiqh, to give you a proof, they will use specific elements. And what we mean by specific elements are specific hadiths. A scholar will open the book of hadith, he'll tell you that Shu'ayb ibn Ya'qub has narrated this hadith from Imam al-Sadiq alayhi salam, and I am basing my fatwa on this hadith. This particular hadith, which means that you should not submerge your head in water, where do you discuss this hadith? Do you discuss this in legal theory or in Islamic law? Which science deals with this? Islamic law. Fiqh or usul? Fiqh. Usul is Islamic legal theory. Usul, principles of jurisprudence. In principles of jurisprudence, we're not looking at any particular hadith. We're looking at the common elements. We'll get to them. Whereas in fiqh, in Islamic law, you're looking at specific hadiths that are specifically applying to that case. So when a scholar, when you ask him, why is it prohibited for a person to submerge their head in water while fasting? And the first step, they will tell you, oh, here's a hadith by Shu'ayb, by Ya'qub ibn Shu'ayb. When they point you to the hadith of Ya'qub ibn Shu'ayb, what science is dealing with this? Fiqh, Islamic law, or usul, legal theory? Fiqh. Why fiqh?
Because it's the hadith itself.
See, because in fiqh you're dealing with specific elements. This hadith from this narrator, the science of fiqh deals with that. Is this clear so far? Okay. So what did the Imam alayhi salam say? The Imam said in that hadith, neither the one in a state of consecration for Hajj, meaning the muhrim, the one who's in the state of ihram, nor the one who fasts may immerse his head in water. They should not do that. So this is a specific hadith. And in Islamic law, when you open the book of Hajj or the book of fasting, when this is being discussed, you will see this hadith there. They will discuss this hadith in fiqh, in Islamic law. In usul, we don't discuss these hadiths, because these are specific elements. Now here's a question. In Arabic, the Imam alayhi salam, in mentioning this hadith, the Imam says, لا يرتمس المحرم في الماء ولا الصائم. That's the Arabic text of the hadith. You have the translation in the book. What does لا يرتمس mean? يرتمس means to submerge yourself in water. What does muhrim mean? The one who's in the state of ihram, doing their hajj or umrah. في الماء, in the water. So don't submerge yourself if you're a muhrim in water. And neither who? The one who's fasting. Now when you look at the Arabic expression لا يرتمس, what does لا يرتمس mean?
Do not.
It's not do not. Because if the Imam was saying do not, he would use the imperative لا ترتمس. What kind of verb is this? يرتمس.
It's a mudari.
Mudara. It's a present tense verb, right? So the very literal translation is that the muhrim, right? The muhrim and the one who's fasting do not submerge. That's the literal translation, right? The one who's in the state of ihram, the one who's fasting, they don't submerge in water. Now, they do not submerge. Is this a command, or this is something that is informing you?
It's an information.
It's a report, it's information, right?
That they do not do this thing.
They do not do this. It's like the Imam's informing you that they don't do these things, right? When you use the present tense verb, لا يرتمسوا, it means they don't do these things. But in common Arabic usage, whenever you say a statement like that, what do the people understand from it? The people understand a command from it. It's like saying, don't immerse yourself in water. So they do not submerge, or just the command, do not submerge, is pretty much the same. That one is using a command, an imperative, like stand up, eat, do not submerge. You're just negating the imperative. Whereas the Imam here is technically using a present tense verb, and he's saying they don't submerge. When an Imam who's giving you a law says they don't submerge, it means don't submerge. It's a command. Technically, linguistically, it's not a command, but what's the common understanding from such a phrase? That's like, for example, you say good people don't go to a bar. Now, if you were a person, a legislator, who's legislating a law, and you say good people don't go to a bar, what does that really mean?
Information.
That means you're just giving you information, or it's a command. If you're a legislator, you're legislating laws, you're the master legislating, and you say good people don't go to a bar, what does that really mean?
People that go to the bar bad.
No, it's a command.
No, don't go there.
It's just a command. It means don't go there, right? It's a given that you're saying, hey, don't go there. Do you see that or no?
I see it, but I kind of like when I hear that, I feel like it's makruh. Like he's saying we don't do it, but he's not saying like don't do it.
It could be makruh, but the common usage in Arabic, whenever you say a sentence like that in Arabic, it means don't do it. It's another way of saying don't do it. Now in English it could be different, but in Arabic this is actually very common.
So whenever
Because the Imam, when he's speaking from authority, as a legislator, someone who's giving you the legislation. So when the Imam tells you that the muhrim and the sa'im does not do this, it means don't do it. Now you could go search for more clues and say, you know what, this is not binding, it may be makruh. But if you're just left with this phrase, the common understanding is that it's what?
don't.
It's don't. It will invalidate your fast. So when a scholar looks at this hadith, he realizes, okay, this is a command that is telling us, don't do it. So let's look at the following sentence. A sentence in Arabic, a sentence using the negative form. What negative form is he talking about?
No.
Does not. La yartamisu. That's the negative form. Of the verb in this fashion, in this way, using the present tense, indicates prohibition according to general usage. The general usage of the Arabs, whenever they would bring a sentence like that, it would mean what? Don't do it. It's a prohibition. He's prohibiting you from doing that. He's just saying it maybe politely, saying it in a formal way. Because sometimes the Imam alayhi salam, they just don't want to sit there and give you commands. Hey, do this, don't do that. Sometimes they'll say it in a sentence like that. You know, a muhrim does not do that. A person who's praying will not ghafa, does not ghafa. You know, it's very common. Now, the narrator of the text is moreover a trustworthy person. He's thiqa. Who's the narrator of this text? Ya'qub ibn Shu'aib. He is trustworthy. And although a trustworthy person may sometimes appear to err or deviate from the norm, we're not saying every trustworthy person will definitely say the truth. No, there's always a chance for them to make a mistake. But the legislator, which is the Prophet and the Imams, acting on behalf of Allah, has instructed us not to accuse him of error. As whenever a reliable narrator, someone who's known to be truthful and doesn't lie, and they bring you a command like that and they tell you, we heard the Imam saying this, accept their word. If they're known to be what? Reliable. Does that mean that 100% whatever they say is true? No. Sometimes they may make a mistake. But for me, between me and God, that's enough proof. Let's say you follow so-and-so marja, and you want to ask him about a ruling. You could not find it in his book or it was confusing. Your friend is going for ziyarah. You tell your friend whom you trust and is known to be trustworthy, doesn't lie, is known to be trustworthy. You tell your friend, go to my marja when you go for ziyarah and ask him this question for me. Is this halal? Is this haram? Is this permissible? Is this not? What do I do in this case? Your friend comes back and tells you, I met your marja, I asked him the question, and this was his response. Is his response binding for you? If he's reliable? Yes. If he's reliable, your friend is reliable, known to be trustworthy, then you have to accept his word. Does that mean that your friend is 100% correct and that they definitely did not make a mistake? No. There's always the chance for someone to make a mistake, but Islam is flexible. Islam is saying, even if you don't have that full certainty, as long as your friend is trustworthy, you can rely on them. Because if God were to say, you can only depend on someone if you have yaqeen, life would be complicated. You can't, on who will you rely? So the author is saying that the legislator has instructed us not to accuse him of error or lying if that person is trustworthy. Indeed, the report of such a person is considered to be authoritative, meaning it's hujjah, it has authority. Hence, the conclusion that immersing one's head in water while fasting is prohibited. So when you ask a faqih, a scholar, why is it prohibited? They'll tell you there's a hadith. The meaning of it means that you should not submerge your head in water, immerse your head in water. And the one who narrated it is trustworthy. We accept their hadith. Let's look at the second one. The jurist will answer the second question in the negative. What was the second question? Do I have to pay khums on inheritance I received from my father? The jurist will tell you no. You do not have to pay khums. Why? Basing himself on a tradition narrated by Ali ibn Mahziyar, in which he defines the types of property that are subject to khums. You have to pay khums on what types of property. The tradition by Ibn Mahziyar specifies that khums is not to be levied on an inheritance passing from father to son. It's very clear that if inheritance is passing from a father to his son, you don't have to pay khums on it. As big as it is. You inherited $1 million from your father, a big piece of property. Do you have to pay khums on it? No. What's the proof? This hadith from Ali ibn Mahziyar. So, or vice versa, a father is inheriting from his son who died, he doesn't have to pay khums. From which it is concluded, in accordance with the normal sense of the words employed. When you look at the words in the hadith of Ibn Mahziyar, you come to the conclusion that it's not wajib, mandatory, to pay khums on inheritance. So what do we conclude here? That the legislator has not imposed the payment of khums in such cases. The narrator in this case is again trustworthy. Ali ibn Mahziyar is trustworthy. And the same considerations mentioned in the previous case apply here too. So a scholar in the science of fiqh is dealing with this hadith, and he wants to issue a fatwa that you do not have to pay khums on your inheritance. What's his proof? It's this hadith. Hence the conclusion that the payment of khums on an estate of inheritance on an estate which is inherited from one's father is not obligatory. A scholar will give you that conclusion. Let's look at the third question. Soon it will become clear why the author is mentioning these examples. What was the third one? Does laughing out loud in prayer invalidate the prayer or not? The jurist answers the third question in the affirmative. Yes, it will invalidate your salah. Basing himself on a tradition from Al-Imam As-Sadiq alayhi salam, narrated by Zurara. Zurara narrates this hadith to the effect that guffawing does not invalidate ablution, but it does invalidate prayer. So if you're laughing loudly while doing your wudu, does that invalidate your wudu? No, it does not. But if you laugh loudly during your salah, if it's a smile, it's okay, it does not invalidate the salah. But if you're guffawing, you're laughing with voice, right? You're actually laughing in your salah, it invalidates it. This is a hadith from who? From Al-Imam As-Sadiq alayhi salam.
But the crying loudly does not.
If you're crying for a worldly matter, somebody died, you lost your business, I don't know, whatever worldly, it does invalidate the salah. But if you're crying out of love or fear for Allah, it's okay.
Or if your parent or somebody died.
Yeah, you can't. You shouldn't. You could cry in the sense that your eyes are tearing, right? There's tears in your eyes. They're tearing up. But if you're crying, like with a voice, like, wailing, crying, that invalidates salah, yes. So you have to make sure while you're praying, you're not loudly crying.
Even if it's in the fear of Allah, you can't cry loudly?
If it's for the fear of, I said, only if it's for fear of Allah. If it's for the fear of Allah or the love of God, you can cry in your salah. But not too loudly where you break the harmony of salah. Let's say someone is just screaming, right? That would invalidate the salah.
Or disturbing others.
Well, the disturbing others is another issue. Does not necessarily invalidate salah. Let's say someone is disturbed even if you cry very softly. That's another point. But we're talking about the salah itself. If you're screaming, from your crying, that would invalidate the salah. But if you're crying gently, normally, out of love or fear of God, then that is okay. But if you're crying for a worldly matter, not just tears, no, you're actually crying, you're making a voice, that would invalidate the salah.
So tears for worldly matters allowed? Like not...
Yeah, tears are okay. Tears by themselves are okay. They don't invalidate the salah. As long as you're not making any noises. Just tears.
If just for a split second, the thought that, say my daughter came into my head for a split second, and for that split second, my eyes watered, but I immediately took it right to Allah.
That's fine.
Okay?
Your prayer is valid in that case, yeah.
Okay.
But if you took a few moments to just sob and cry,
On the missing her, that would...
that feeling of missing her is okay. But if you started to cry loudly in your prayer, like sobbing and just crying loudly, that would invalidate the prayer. But what you described is valid, it's okay. So we have a hadith that says if you guffaw in your salah, it invalidates it. And Zurara, who's narrating this? Zurara, and he is reliable. Now let's go to the following paragraph. Here's the important point. The rulings given by our jurist in answer to these three questions related to different areas of concern. One of them is about fasting. One of them is about prayer. One of them is about inheritance and khums. We see we're talking about different cases and subjects here, right? Now, the evidence that he relied on in each case was also different. If you ask the scholar, what was your evidence for that first question about fasting and immersion in water, he'll tell you it was that hadith by Yaqub ibn Shu'aib. And you ask him, what about the Khums issue on inheritance? What was your evidence? He'll tell you, my evidence was the hadith by Ali ibn Mahzayah. When you ask him about the third question, which is what? Laughing in salah, he will tell you, my evidence was the hadith of Zurara. Are these all the same evidence or different pieces of evidence? Different pieces of evidence. So in fiqh, in Islamic law, each ruling, each case has its own evidence, its own hadith that you're basing your opinion, your ruling on, your fatwa on. Is that clear? That in the science of fiqh, or we call Islamic law, in Islamic law, every case has its own what? Oh, its own evidence. So each of the three traditions has its own text and linguistic structure, the meaning of which must be separately determined. You have to look at each hadith and see what you understand from that hadith. Common elements are, however, seen to have been used by the jurist in all three cases. In examining all these three hadiths, there are some common elements that you used in all three. This is legal theory. This is what we study in Usul. Those common elements. We're not looking at any particular hadith now. We're just using common tools when dealing with all these three hadiths. Such as what? Give us a few examples. One of those elements is reference to normal linguistic usage in understanding utterances made by the ma'soom. We have something in Usul, in legal theory, called Hujjiyat al-Zuhur al-Urfi. What does al-Zuhur al-Urfi mean? Al-Zuhur al-Urfi, we can translate it as normal usage. Normal usage. And Hujjiyah means the, authority or validity. Validity. Let's go back to this example. لا يرتمس المحرم في الماء ولا الصائم. Someone who's muhram or fasting does not submerge, does not immerse himself in water. We said that in Arabic, such a statement means what? Means it's prohibited, right? Who says it's prohibited? The Imam did not directly, explicitly say it's prohibited for a fasting person to immerse himself in water. Did the Imam say that? No. What did he say? A fasting person does not immerse himself in water. That's all the Imam said. How did we conclude that a fasting person, it's prohibited for him to do that? How did we conclude that? Based on normal usage. When you go to that society who speak that language and you give them a sentence like that, what do they say? They tell you it means it's prohibited. How did we arrive at this conclusion that it's prohibited? Through normal usage, and normal usage is valid for us. It has authority for us. Because the Imams did not invent their own language. They did not invent their own mode of communication. How did they communicate to us? Based on the standards of communication in that society, right? They relied on that mode of communication in their society to speak to us. Did they invent a new way? No, they did not. All prophets of God. They did not invent a new language, a new system of communication. The Imams would speak how the people used to speak. They would use the standard rules that people would use, the standard words that people would use, right? We call that normal usage, al-dhuhur al-urfi. Or you don't even have to say urfi. For short, in usul we call it hujjiyatul dhuhur. That's what it means. Hujjiyatul dhuhur means that normal usage is what determines the meaning of the hadith. Now, in order to understand the meaning of the hadith, do you open in the dictionary and see the word la means no, this means immersion, this, no. That's not how you figure out a meaning. You don't go to a dictionary and just look at the word. You have to look at the whole sentence and give that to the people who speak that language and see what is the normal usage. What is the apparent meaning of this sentence? What do Arab-speaking people understand from such a sentence? This that I just described, normal usage, the hujjiyatul dhuhur, the authority or validity of normal usage, where do we discuss that? In which science? In legal theory. Why? Because this applies to every hadith. Every hadith has a normal usage, has hujjiyatul dhuhur. Is this specific to a certain chapter in Islamic law, like Hajj, fasting, prayer, business transaction? Or it applies to every book in Islamic law and every hadith? This applies to everything. It's universal. It's called a common element. Hujjiyatul dhuhur, this normal usage, is a common element. So we discuss it in legal theory, not in Islamic law. The hadith of Ali ibn Mahziyar about Khums, we don't discuss it in usul. It's specific to that case in Islamic law. Once you get to the book of Khums in Islamic law, then you will discuss the hadith of Ali ibn Mahziyar. But what does the hadith of Ali ibn Mahziyar mean? What do those words mean when put together? That's called normal usage. Where do we discuss that? Islamic law, legal theory, usul. And this applies to every single hadith. Regardless of its content, what it's talking about, it applies to every single hadith. Because why do we discuss this? You could say, you know what? You know, this is obvious. Why are we even discussing this? First of all, this is not obvious. Some Arabic sentences are quite complicated. And even the experts will disagree what that means. Or like you mentioned, you know what? I could take this statement and said, this is makruh for you to do. It's undesired for a person who's fasting to immerse himself in water. It doesn't really mean it's haram. It will invalidate the fast, right? So there could be some disagreement. Where do we discuss this?
In legal theory. In
legal theory, you sit armed with your proofs, you discuss this. This type of a sentence that has a negating in it, they do not submerge. Right? It's not a direct command. You were using a present tense verb. What does that mean? In what science do we discuss all of this? Usul. That's where we discuss it. This is an example of a common element. Let's continue with the text to see some other common elements. So, one of those elements is reference to normal linguistic usage in understanding utterances made by the ma'soom. This is termed the validity of the apparent meaning as determined by normal usage. The apparent meaning that you get from normal usage. We call this hujjiyatul dhuhur. Hujjiyat al-dhuhur al-urfi. Another common element that we find in all of these three hadiths is the authority of a tradition narrated by a trustworthy person. So in Islamic law, we looked at the hadith of Yaqub ibn Shu'aib. We looked at the hadith of Ibn Mahziyar. And we looked at the hadith of, who was the last one? Zurara. Right? The first hadith, Yaqub ibn Shu'aib, you do research about him and he's reliable. Ibn Mahziyar, reliable. Zurara, reliable. This you deal with in fiqh. You go and do research, whether they're reliable or not. The next question, who says the hadith of one reliable person has authority, is valid, and you can issue a fatwa on? Who says that?
Based on experts that studied the biography of the people who narrated the stories?
No, let's say we accept that this person is trustworthy.
Oh,
I did my research, Yaqub, he is trustworthy.
okay.
Who says I have to accept the word of a trustworthy person?
That's where legal theory.
That's where legal theory comes. In legal theory, we discuss this whole notion of accepting the hadith of a thiqah, of a trustworthy person. Because there have been scholars in the past who don't accept this. A scholar will tell you in the past, look, you didn't hear the Prophet say it, the Imam say it. Maybe this trustworthy narrator made a mistake. How do you know? Maybe he misunderstood the Imam. Do we always understand each other correctly? No. Especially when you're dealing with laws and details, people can easily misunderstand. How do you know that Yaqub ibn Shu'aib did not misunderstand the Imam? How do you know he didn't paraphrase and he changed the meaning? Same with Ibn Mazyar, same with Zurara. How do you know? Which science deals with this idea or principle that says, accept the hadith of a reliable person? We don't study that in fiqh. In fiqh we just apply that. Where do we study this principle itself and develop this principle? In legal theory. And there's some disagreements, you know. Many scholars have different conditions on whose hadith can you accept. Just any reliable person, or no, there are some criteria involved here. Or what's the proof? What's the proof that you have to accept the hadith? Is there a hadith? Is it an intellectual proof? What is the proof? Because you could argue, and some have argued in the past, that it's not really binding. Let me give you an example here. Let's say on Sunday you go to Walmart and you park in those parking spaces which are specific for the disabled, right? For the handicapped. What do you call those parking spaces? Just those spaces for the handicapped, right? The blue parking spaces. Your friend, and he's trustworthy, reliable, comes and tells you, look, there's a new law in the city of Dearborn that on Sundays you can park in those spaces. You don't have to be disabled. Okay? And he's reliable. You go and you park there. You come out, you're ticketed. You go to court. And you tell the judge will tell, why did you park there? You tell Mr. Judge, my friend, who's reliable, told me that on Sundays we can park there. Is that justification for you? No. Can the judge still fine you? Absolutely. The judge will tell you, look, I mean, I'm not saying you're a bad person by following your friend, but at the end of the day, it's the law. Someone misinformed you about the law. You didn't have certainty. You should have asked for proof. You know, where is this law? Can I see it? If you show me law on paper, okay, I won't fine you. But as long as you did not see that, I will fine you. So you see, you could always ask this question, who says the narration of any reliable person is binding? Maybe Islam wants me to have yaqeen and certainty. Right? Where do we discuss that? In legal theory. In legal theory, our scholars sit and they will prove to you that in Islamic law, it's acceptable for you to take the hadith of a reliable person. And that's valid, it's acceptable. So don't say, okay, it's obvious that you can accept the report of someone who's trustworthy. No, it's not so obvious. Even in our own legal system, it won't fly. If you violated the law, just because you depended on a trustworthy person, that doesn't fly. So in Islamic law, the hadith of a trustworthy person is accepted. But where do we discuss its criteria and the details surrounding it? In which science? In the science of usul, in legal theory. So that's another common element. Accepting the hadith of someone who is trustworthy, this is called a common element that we discuss in Islamic law. Therefore, we see that the process of arriving at a fatwa, deriving an Islamic law, involves two types of processes. One is the specific elements. Go find the hadith in this book about fasting, about Hajj, about Khums. Who's narrating the hadith? Are they reliable? Are they not? These are specific elements. Then once you've done that, you come to the common elements. Okay, this wording that was used in the hadith, what does that mean according to common usage? Number two, the one who's narrating the hadith is reliable. Do I have to take the word of a reliable person or not? These are common elements. The specific elements we discuss in Islamic law. The general common elements we discuss in legal theory and usul. Once we've developed them, these common elements, we've discussed them, developed them, then we take them to Islamic law and we apply them there. So all of these common elements, the area of application is where? It's fiqh, it's in Islamic law. But where do you develop these common tools in legal theory? Is that clear?
So basically fiqh is taken into legal theory, analyzed, then taken back into fiqh?
See, in fiqh, you're doing two things. First of all, you have to look for specific. See, when you're deriving an Islamic ruling, this is all done in fiqh. You're sitting in fiqh. Number one, you're deriving what? The hadiths. Who gives you those hadiths? The books. Kafi, Man la yahdharuhu al-faqih. They give you the specific hadiths, right? And then you do research, whether the narrators are reliable or not. Where do you go for that? The book of Najashi, the book of Shaykh al-Tusi, the biographies, right? You're gathering, you're just collecting the data. And then step two, you take the common elements that you discussed and developed in usul, you take those common elements, you apply them to these hadiths, and you get a conclusion.
So trying to figure out if someone's reliable or not, you don't do that in fiqh, you do that in usul.
No, you don't do that in usul. Usul says, I don't care who's reliable or not. I'll just give you the principle. Whoever is reliable, take his hadith. That's what I'll tell you. That's what usul tells you. Whoever is reliable, take his word. But if X is reliable or not, usul says, I don't care about that. You go do your research, who's reliable or not. I'm not going to tell you Zayd, Bak, Zurara, they're reliable or not. That's not my job. Usul says, that's not my job. Go in fiqh, in the science of biographies, in the science of hadith, figure it out there. But I will just tell you, in usul will tell you, the legal theory, the science of legal theory, it will tell you, whoever's reliable, take his word. That's all I'll tell you. But who's reliable or not, that's not my job.
So fiqh is a specific branch of usul.
It's not a specific branch of usul. Fiqh is a science that needs the tools from usul to apply it to the hadiths that it has. That's fiqh. Later on, he will give another interesting example. Let's say a carpenter. In order for you to produce something as a carpenter, you need the material, the wood, right? Where do you get that wood? The science of fiqh. In fiqh, you get the raw resources, the content, the material. Where do you get that? In fiqh. So a carpenter needs the wood. But the wood, is that enough? What do you need? Tools, right? You need a saw, for example, to cut the wood, right? So now that you have the tools as well, how do you go about creating an object. Taking that tool, turning it on, using it properly. That's usul. It's giving you the common tools. See, you could be making a chair as a carpenter, or a desk, or a closet, or something else. It doesn't matter. You're still using the same saw, the same tools. Could be different wood. The saw says, I don't care what you want to do. I just cut, and that's it. That's my job. What am I cutting? I don't care. You're cutting me to make a chair. You're cutting me to make a closet. You're cutting me to make a door. It's none of my business. My business is to cut. Legal theory says, what kind of hadith you're dealing with? Is it about salah? Is it about sawm? I don't care. Yaqub ibn Shu'aib, he's reliable or not? That's not my business. I don't tell you that. You go figure it out. But once you bring all these parts together, the hadith and the narrator is reliable, okay? I will tell you how to use all of that to arrive at an Islamic law. I will give you the tools. One of the tools is what? That every reliable narrator, their hadith is valid. Another tool is this common usage and the normal usage that we mentioned. That whenever a sentence has an apparent meaning in that language, you take that meaning. Where do we discuss that? In usul. So usul gives you these common elements. Is that clear? We'll give a few more examples, but yes.
So basically, it's to see if the hadith or idea that you're trying to convey will hold on its own with and without hadith. Is that what the whole thing is? Like
Usul, legal theory. Can you state that again?
to have the idea or the law by itself hold on its own, with or without the hadith that's being analyzed.
See, usul is just showing you how to deal with the hadith. You have a hadith about a specific case. What does the hadith mean when it's using a negation? Usul tells you how to deal with this structure, with this linguistic form. Usul tells you, go find out if Zurara is reliable or not. Go find out. It's not my job. I won't tell you. Don't discuss that in Usul. Go find out. You went and you did your research and you came to the conclusion that Zurara is reliable. Then you come back to Usul and you tell Usul, look, Zurara is reliable. Now what do I do? Usul tells you, okay, he's reliable and this hadith means it's prohibited, then don't do it. It gives you the conclusion. That's what Usul does. And this process that I just described applies across the board. It applies in the law of, in the book of prayer, the book of fasting, the book of Hajj. It applies everywhere. It teaches you how to deal with a hadith in every book. Is that clear? Any questions about that? So basically, we have the specific elements which we discuss in fiqh, and we have the common elements which we discuss in usul. That's the main difference between the fiqh and the usul. وصلى الله على محمد وآله الطاهرين. اللهم صل على محمد.